So I call this meeting to order. Welcome to meeting number 80 of the House of Commons Standing Committee on Public Safety and National Security. Pursuant to the order of reference of Friday, November 25th, 2022, the committee continues consideration of Bill C-20, an act establishing the Public Complaints and Review Commission and amending certain acts and statutory instruments. Today, the committee resumes clause-by-clause consideration. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I would like to make a few comments for the benefit of officials and members. Please wait till I recognize you by name before speaking, with some flexibility when being questioned from members, of course. Though this room is equipped with a powerful audio system, feedback events can occur. These can be extremely harmful to interpreters and cause serious injuries. The most common cause of sound feedback is an earpiece worn too close to a microphone. In order to prevent incidents and safeguard the hearing health of the interpreters, I invite participants to ensure that they speak into the microphone into which their headset is plugged in, and to avoid manipulating the earbuds by placing them on a table away from the microphone when they're not in use. Finally, a reminder that all comments should be addressed through the chair. I draw the attention of the committee and witnesses, of course, that we have resources until midnight. This does not mean that we need to sit until midnight. My my hope, and I'm sure it's a hope shared by all, that we can get through this bill in short order. I think we're this close to being done. So at the end of a couple hours, if we want to take a look at where we are and decide whether we want to continue or to resume again the following day, I think that'll be up to this decision. What's that? No offense, let's go then. Okay, well, I admire the enthusiasm. So I will now welcome the officials who are with us once again, still. They're available for questions regarding the bill, but will not deliver any opening statements. So, from the Canada Border Services Agency, Kathy Malte, Director, Recourse Directorate. From the Civilian Review and Complaints Commission for the Royal Canadian Mounted Police, Joanne Gibb, Senior Director, Strategic Operations and Policy Directorate. Leslie McCoy, General Counsel. From the Department of Public Safety and Emergency Preparedness, Randall Coops, Director General, International Border Policy, Martin Lukes, Manager, Border Policy Division, Deidre Pollard-Bussey, Director, Policing Policy. And from the Royal Canadian Mounted Police, Kathleen Clarkin, Director, National Recruiting Program, Alfredo Bangloy, Assistant Commissioner and Professional Responsibility Officer. So thank you all for joining us today. So we are at Clause 52, Amendment NDP 34, and I have no idea where we left off, but so let's if there's any discussion further discussion on this amendment, I invite people to raise their hands at this time.
If I could ask a question, Chair?
Mr. Motz.
I just wanted to know from the officials whether there's a concern raised with changing the wording as it's written in NDP 34. I mean, basically, it's a must to a may, but taking out all the other language there, is that going to pose a problem, or are we okay with 34 NDP 34 as it is?
Mr. Chairman, I think we would observe that the government's preference was for the language that was presented in the bill in the form that it was introduced. If it would be helpful to the committee, I can explain some of the considerations that were at play in the design of Clause 52, which deals with restrictions on the things that the Commission may and may not investigate. You'll note that there is a subsection that deals with where the Commission may refuse and a subsection that deals with where the Commission must refuse, and so on. The design intent for the Commission as presented in the bill was to give the Commission the broadest possible latitude of decision-making about what to investigate within the four corners of its jurisdiction, but to not give the Commission discretion about making decisions about where the limits of that jurisdiction lay. These amendments would, to varying degrees, grant the Commission authority to make decisions, broader decisions, about what would fall within its mandate as a discretionary matter. As my colleague pointed out at the last meeting, that could allow the Commission to ensure that a type of complaint that was unforeseen does not fall through the cracks. It could also, though, on the other hand, give rise to workload concerns. It could give rise to conditions where, or situations where the Commission's mandate is brought into conflict with a space that is reserved in statute for another body. So really what the amendments at 52 do, as Mr. Motz noted, is the line drawing exercise or the balancing exercise between just where should the Commission be given the discretion about what falls within its mandate, in addition to its discretion, its absolute discretion about what is already defined as within its mandate. And I think that's a question that the committee is best placed to answer.
So, I appreciate that. I think you're on the money with that. Would it still be appropriate moving into the Block 13? I know we've jumped ahead, but to change the must to may, would that substantially change the intent of 5 as we're talking here in the Act?
It would change the intent. The question for the committee to consider is whether that's a desirable outcome.
Okay, thank you.
Does my colleague from the Commission have any? No? Okay.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson. I was just having a bit of trouble there. I just wanted to reiterate this. We said it at the last meeting, but we've had a number of discussions since then. Just to reiterate that NDP 34 and BQ 13 are very similar. BQ 13 comes right afterwards. The intention is, well, in the NDP amendment, it goes a bit further, that the Commission can refuse to review the complaint if it believes that it could seriously compromise an investigation that is underway. And that wording is not in the initial bill. And I would propose the following, that the Commission can refuse to review the complaint, full stop, period. And the initial text would remain, in the bill, would remain as is. I think that the wording in it is better. So I would vote against NDP 34, but my intention was the same as Mr. Julian's, and I'd call on my colleagues to follow suit.
Thank you for the intervention, and I should have reiterated that caution. So if NDP 34 is adopted or defeated, PV4 cannot be proceeded with since they are identical. Also, if NDP 34 is adopted, BQ 13 cannot be moved due to a line conflict. Mr. Shipley.
Thank you, Chair. Just want to get this out there so everybody knows. We will not be able to support NDP 34, but we will be supporting Block 13.
Thank you. Any further interventions? Mr. Julian, go ahead.
Just to reiterate, Mr. Chair, as I did at the last meeting, that this recommendation comes from the Canadian Association of Refugee Lawyers, and their concern around this particular amendment is that simply the scope is too large for a commission to refuse to deal with the complaint. This would tighten the language considerably. I urge members of the committee to vote for NDP 34. If it is defeated, I will be voting for BQ 13, which at least gives the Commission some leeway in whether or not to use the loopholes that are open to it.
Thank you. Anybody else? All in favor of NDP 34? A very strong support over there. Yeah. All opposed? Unfortunately, it seems to not quite have made the cut. So, okay, so that brings us to Block 13. Note to Chair: if Block 13 is adopted, PV4 cannot be proceeded with due to a line conflict. Madame Michaud, allez-y, s'il vous plaît.
Please proceed, Ms. Michaud. Thank you very much, Mr. Chairperson. So I think I've spoken about this amendment enough. it would provide the Commission more leeway in order to refuse to investigate. So I'd invite colleagues to vote in favour of it.
Thank you. Any further interventions? Seeing none, all in favour of BQ 13? Opposed? None? Carried. So PV 4 cannot be moved. It brings us to NDP 35. If NDP 35 is adopted or defeated, PV 5 cannot be proceeded with since they are identical. Mr. Julian, if you please.
Members of the committee will be happy to hear that having already had this discussion, that I'll be withdrawing NDP 35.
Oh, withdrawn. That brings us to PV 5, which is deemed moved. Is there anyone who wishes to speak to PV 5? Seeing none, all in favor of PV 5? Opposed? Defeated. That brings us to G5. Who wishes to move G5?
Thanks, Mr. Chair. So this is just a minor change, and it clarifies the English to align with the French to affirm that the PCRC has discretion to determine whether dealing with a complaint would compromise or seriously hinder the administration or enforcement program legislation.
Thank you. Any discussion? Seeing none, all in favor of G5? Opposed? Carried. Brings us to NDP 36.
Et les membres du comité vont être
Members of the committee are going to be delighted to know that since we've previously had a discussion relating to this amendment, I'm going to withdraw NDP 36 as a result, and also NDP 37.
Thank you. Moving on, therefore, shall clause 52, as amended, I believe, carry. All in favor? On division? Okay. That brings us to NDP 37, which is withdrawn. And now to block 14. Allez-y, s'il vous plaît.
Merci, Monsieur.
Thank you, Mr. Chairperson. BQ14 is a concordance amendment for the amendment that we just voted on that states that the Commission can refuse a complaint rather than must do so. So it's logical that we adopt this amendment as well.
Any discussion on BQ? Mr. Shipley, go ahead.
Yes, thank you, Chair. We just need a little bit of clarification on this from the officials. What would this do? What would this amendment do?
Our understanding is that it ensures concordance with the previous BQ amendment.
Yes, I understand now, yeah.
Okay, any further discussion? All in favor of BQ 14? Opposed? Carried. Brings us to NDP 38. Mr. Julian, please.
Monsieur très content de savoir, Monsieur le Président.
You'll be delighted to know, Mr. Chairperson, that we've already had a discussion on this particular topic and the committee decided not to move ahead with it, so I'm going to withdraw NDP 38.
Thank you. NDP 38 is withdrawn. Shall clause 53, as amended, carry? On division? Yeah? Okay. Shall clause 54 carry? On division? Shall clause 55 carry? On division? Brings us to clause 56 and CPC 21. Note to chair, if CPC 21 is adopted, G6 cannot be moved due to a line conflict. Mr. Shipley or whomever, would you like to move NDP 20, or sorry, CPC 21?
We've been working very well together, but no, I'm not going to move any NDP ones. But I also will be withdrawing and not moving this amendment, Chair.
Very well, thank you. That brings us to G6. Mr. Gahir, did you wish to move G6?
Yep. Thank you, Chair. This is, we're just adding in the word prescribed and taking out the words provided for in the regulations. And as far as I can tell, this amendment is recommended to better align the English and French and to ensure that the regulations around the RCMP and timelines align. But we can hear the experts out on this.
That's that question of
No, sorry, so the witness is Mr. Coops.
Mr. Coops? Okay.
That's correct. It would align the English better with the intent as expressed in the French version of the statute.
Very well. Any further discussion? Seeing none, all in favor? On division. Carried. Okay. So shall clause 56 as amended carry? On division? Okay. Clause 57 and CPC 22.
Thank you, Chair. We will not be moving this amendment.
Okay, withdrawn. Shall clause 57 carry? On division? Clause 58 with CPC 23. Withdrawn, okay. Shall clause 58 carry? On division? Clause 59, and we go back once again to Mr. Julian with NDP 39. I should note that if NDP 39 is adopted, CPC 24, NDP 40, and BQ 14.1 cannot be moved due to a line conflict. Also, if NDP 39 is adopted or defeated, PV 6 cannot be proceeded with since they are identical. Mr. Julian.
I will withdraw NDP 39, Mr. Chair.
Very well, thank you. Withdrawn. That brings us to CPC 24. If CPC 24 is adopted or defeated, NDP 40, Block 14.1 cannot be moved since they are identical. Also, if CPC 24 is adopted, PV 6 cannot be proceeded with due to a line conflict. Mr. Shipley.
Thank you, Chair. We will be moving CPC 24. This is the Bill C-20 in Clause 59 be amended by replacing line 32 on page 40 with the following. The parties and the union representatives for the RCMP and employee of CBSA employee, as the case may be, whose conduct is the subject matter of the complaint, and the other person who satisfies the.
Thank you. Is there any discussion? Mr. Motz.
So I'd just like to ask the witnesses, if we could, whether there's any issue with the addition of the language that we're proposing in CPC 24. And what's the impact that'll have on how the commission will conduct its investigation or the reports?
I think the intent of the clause before the amendment would have satisfied that in any condition because there was nothing that would stand in the way of the commission allowing union representatives to make representation provided they satisfied the other conditions for participation.
Is it a flaw to have the language added for greater clarity?
I think we would suggest it's unnecessary. I don't know if we would conclude it's a flaw.
Thank you, Mr. Chair. Because CPC 24 is identical to NDP 40, I will be supporting this amendment. I think it provides further clarity and strengthens the ability to intervene in hearings.
Any further interventions? Seeing none, all in favor of CPC 24? Opposed? None? Carry on. Carried. Okay, so PV6 cannot be moved. That brings us to NDP 40, which cannot be moved. And 14.1 cannot be moved. So shall clause 59 as amended carry? All in favor? On division? Okay. Brings us to clause 60, NDP 41. Mr. Julian, if you please.
Thank you, Mr. Chair. This is a recommendation that came to us from Breaking Barriers, a concern that arose out of the Merlo-Davidson lawsuit, that there was a complaint undertaken under internal investigation. And so currently, the way the bill is worded, the Commission may suspend an investigation, review, or hearing with respect to a complaint if it's an opinion continuing it would compromise or seriously hinder an ongoing civil or administrative proceeding. That is the power to suspend in clause 60.2. And so what this amendment would do, NDP 41, would strike the word administrative proceeding, which is internal, of course, the RCMP, and taking the lessons of the Merlo-Davidson lawsuit, limit the Commission's ability to suspend the investigation to whether it would compromise or seriously hinder an ongoing civil proceeding.
Thank you. Any discussion? Mr. Motz.
Thank you. Thank you, Chair. I don't know if I can support this because I think having administrative proceedings also are critically important. That may cause it may cause the investigation to be that's what I'm looking for, 31, to be suspended. And I don't think limiting it to only civil, an ongoing civil proceeding, and not anything including administrative proceeding would benefit a complainant, the person being complained about, or the agencies who do the investigation. And I would appreciate any feedback from our witnesses on that, whether limiting it, removing the administrative proceeding would be a significant flaw or issue with that's removal.
From the RCMP perspective, it potentially could have an impact if we're removing administrative proceedings, because within our administrative proceedings, one of them anyway is proceedings where we're seeking the dismissal of an RCMP member, and removing that potentially could allow this PCRC to interfere or hinder that proceeding.
Mr. Coops?
I would agree. I think that we would offer the view to the committee that the Commission should, in fact, retain the discretion. This is in the may suspend section of the duty to suspend. The Commission should retain the discretion to suspend an investigation in an administrative proceeding, bearing in mind, in addition to the ones the RCMP have identified, serious incident investigations would fall within the intent of an administrative proceeding, or within the ambit of an administrative proceeding, rather, and the Commission should have the discretion to suspend on those grounds.
What about CBSA? Do you see any challenges with that's removal as well?
I do. So, for example, an appeals process, so somebody that wants to appeal an enforcement action, a seizure at the border, we consider that an administrative process, and there's legislated timelines attached to that. So the complainant may lose the chance to proceed with their appeal if the PCRC has to take over the complaint, and then that would, split it all out.
Right, thank you. I can't support NDP 40. Sorry, Peter.
Thank you. Mr. Shipley.
Thank you, Chair. I'm not sure who to address this question to, maybe one of the officials. Mr. Julian mentioned, and he's mentioned a couple times, and forgive me for not recalling this if it was brought up in witness testimony before, the Merlo-Davidson lawsuit. I'm not looking for a real long legal brief on this from anybody. Could someone just remind me what that lawsuit was and how that would pertain to this amendment and how that would adjust that and be affected by that, please?
Yes, the Merlo-Davidson lawsuit was a class action lawsuit where approximately $125 million was paid out. And Justice Bastarash issued a report on that, very critical of the RCMP's handling of a number of complaints, and spoke of quite a number of things, including a toxic work environment.
Well, just, my follow-up to that then was then this amendment to maybe the officials, how would that affect or not affect really what was found in that lawsuit, this amendment? Would there be an effect on that? Or any outcome?
Well,
and I know that's speculation, but...
Just with respect to the RCMP's discipline process and conduct board proceedings, which are administrative processes, under the existing proposed clause, the PCRC would have the discretion to suspend an investigation if it would interfere with that process. Removal of that would remove that discretion, I guess, from the PCRC, is my understanding of it, which could then potentially interfere with a discipline process where the RCMP is seeking to dismiss a member from the force.
Okay, thank you. And was anybody else's hearing going in and out there a little bit, Chair? No? Okay, maybe it's just me, but or maybe it's just my ears. So, all right, thank you for that. Thank you, Chair.
Okay, any further intervention? Mr. Julian, of course.
I just wanted to respond to Mr. Shipley. It's a very valid question, but it's not really the Merlo-Davidson lawsuit that I'm referencing. It's the recommendations coming from Breaking Barriers, and they reference the lawsuit. So would this have a material change in the lawsuit? Of course not. But what organizations have come forward to this committee to make recommendations on improving the bill have put forward what they see as best practices in terms of refining the bill, improving the bill, so that the lessons from the Merlo-Davidson lawsuit are learned. So it is the opinion of Breaking Barriers that this is one of the helpful amendments that would improve the bill.
Thank you. Any further discussion? Seeing none, all in favor of NDP 41? Opposed? Defeated. Shall Clause 60 carry? On division? Okay. Shall Clause 61 carry? On division? Shall Clause 62 carry? Shall Clause 63 carry? On division? Brings us to Clause 64, NDP 42. Mr. Julian.
Thank you very much, Mr. Chair. This is another recommendation coming from Breaking Barriers, inserting the word binding in front of recommendations in the interim report 64.1. So that recommendation is to try to ensure that recommendations that are brought forward are actually implemented, and that was the recommendation they made to committee.
Thank you. Any, Mr. Motz?
Officials could help me with this. So we're talking about the commission, which is to be an independent body of both the RCMP, separate from the RCMP and the CBSA. And they're making the suggestion that we're going to add the word binding recommendations there. Do you find that may pose some challenges with those organizations that, I think making recommendations is one thing. Making binding recommendations might be somewhat problematic, and I certainly appreciate hearing from both agencies and the department on that.
Well, I can go first on that. A binding recommendation, which sounds a lot like an order, is very much outside the government's intent in the design of the entire review regime. The regime is predicated on an independent body that operates at arm's length, but then makes recommendations to the minister or the relevant deputy heads. Those deputy heads, in turn, being accountable and answerable to the minister, who is answerable here for the decisions that are made in response to the recommendations. If the Commission begins to issue binding instructions to those agencies, the concern is that that begins to erode on the axis of accountability that exists between ministers and deputy heads and established throughout the federal statute book.
Right, and so I'd like to hear from the RCP and CBSA on how this might create some challenges for both of those, you two agencies.
Yes, for the RCMP, although the vast majority of time, I'm not sure of the exact percentage, but a very high percentage, the RCMP agrees with the recommendations of the CRCC. Making the recommendations binding would have a very significant impact on operations and potentially service delivery, depending on the nature of what the recommendation is. It would effectively give control of certain aspects, whatever the recommendation is, to the CRCC.
There'll be negative impacts, if I heard you correct. You didn't say negative, but you said it would have significant impacts.
And depending on the nature of the recommendation. For example, if it impacted resources, or there was, again, I can't think of a specific example, but binding recommendations, I can just say, would have a significant impact, both operationally, potentially, and with service delivery.
CBSA?
Well, we're not under this CRCC yet, so we haven't had any recommendations, but I could see examples if a recommendation came specifically that we needed to have X amount of resources per shift at a port of entry, then if that were binding, then that could be a major issue from a funding perspective, resources perspective, that we're not able to meet that. Or if there's legislative recommendations that for us it's in legislation, then it may not be possible because there's law that we have to follow. So I could see concerns, but again, it's just assumptions because we're not part of it yet.
Okay, thank you.
Thank you, Chair. Along with my colleague, I too have some issues with this. Just the words themselves, I mean, they would make recommendations binding. Recommendations are recommendations. I have concerns, like Mr. Mons was saying, to make these binding. The officials mentioned about an independent body. If it's independent, making this binding makes that a little bit less independent, does it not? Or how would that work?
That would be one of the risks of giving the Commission order-making power, yes.
Because as it would stand right now, the recommendations would come forward, as you mentioned, to the, and then the ministers and the staff would have the approval as to implement them or not. And we would have no idea, obviously, the specter of those recommendations can be huge and varied, and they may not be implementable for many reasons. So to put them binding would really be tying their hands to something that maybe could not be done. Am I correct in that?
Correct. It would erode the authority of the deputy heads to administer their organizations and potentially erode the authority of the minister to issue directions to both of those agencies. The minister, of course, now is the only person who can issue a directive to the deputy head, to the commissioner of the RCMP, or to the president of CBSA. Adding another person into that mix with directive or order-making powers complicates that accountability relationship and erodes the obligation of the deputy heads to answer to the minister, who in turn answers here.
Thank you for that clarification. Obviously, from the information I'm hearing and taking from that, I won't be able to support this unless I hear something new or different after this, but I won't be able to support this amendment. Thank you.
Thank you, Mr. Lloyd.
Is there a potential, witnesses, that, a recommendation from the commission could be for legislative changes that Parliament would be required to enact? And if we were to say that this was binding, would that put an onus on Parliament to change the law based upon the recommendations of this committee?
My understanding of the amendment is that it would not bind Parliament. It could result in a situation where the two agencies, which both have law enforcement roles, are in an extreme case perhaps subject to direction from an outside body who does not have the legislative authority otherwise to direct law enforcement operations.
Great. Thank you. Any other interventions? Seeing none, all in favor of NDP 42? All oppose? A valiant effort. Thank you. That brings us to NDP 43.
I was actually thinking of ordering, asking for a recount, Mr. Chair, but yes, see if those chads are hanging. So this is NDP 43 is Breaking Barriers recommendation that was brought to this committee that was concerned in clause 64 that the ability to respond on reports that are issued, reports following investigation or hearing, that the six months period for response, particularly for victims who have been through a very long process, it could be very much re-traumatizing, leaving it for that long a period. So the recommendation in NDP 43 is to limit that response period to 90 days. That provides for a much more rapid response in terms of the report. And as we have said all along this process, Mr. Chair, and I know you've repeated this, justice delayed is justice denied. Putting that response period, cutting it in half, is a way of speeding up the response and the justice ultimately that must come to victims.
Thank you. We go now to Mr. Mayilo.
Thank you, Mr. Chair. That's pretty good. Malolo, whatever. You can just call me
I'll
Eric.
work on it.
That's fine. Yeah. You haven't said it too much, so I'll give you some slack. I appreciate Mr. Julian moving this forward, the thoughtfulness he had in doing so. Mr. Chair, looking at it, I mean, I believe personally that that the current timeline is sufficient, but I'm curious to hear from the witnesses, whoever would like to make a comment on it, about how feasible this is from your point of view. Whoever wants to start.
From the RCMP perspective, we currently have an MOU with a 6-month timeline, and we're currently able to meet that service standard. Reducing it in half would significantly impact resources as far as our ability to do these reviews and responses in half the time that we are currently doing them in.
This is a new provision, and legislating a timeline for the responses is, in the government's view, a very important new accountability measure that's being introduced here. The government's proposing 6 months for a few reasons. One is, as my RCMP colleague has said, that is known to be a workable timeline because the Commission and the RCMP work on that timeline now. That is, in fact, the timeline that was recommended by the chair of the Commission to the Minister, and I believe to the committee here. And that also responds to the recent federal court jurisprudence that examined the adequacy of responses of the RCMP to the Commission, in which the federal court identified 6 months as the appropriate length of time. So this provision in the bill is a response to the most recent federal court decision on the matter.
Mutz?
Okay, excuse me, can you refresh my memory on, I know the RCMP has a 6-month investigative window where they report back. I've heard the CBSA say that you have a 40-day report back window. The Commission has currently what? When you get a complaint and you're working on it, what is your general timeline? 6 months still?
So when we conduct a review, the duration depends on a number of factors, including how long it takes for the Commission to receive the relevant material from the RCMP.
Okay, so the way this act reads, though, the way this Section 2 reads here in 64, subsection 2, is that once, if you, as the commissioner, or I guess it would be the commissioner of the RCMP or the president of CBSA, receives the report, they have to have a written response. So I guess it applies more to those two agencies than it does the commission at this point in time. Would that be an appropriate suggestion?
Yes, but because it's the response to the Commission's report back to the agency heads, yes.
Okay, all right, thank you.
Madame Michaud, allez-y, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson. I had exactly the same question as my colleague, and in light of the responses from officials and colleagues, I cannot support Mr. Julian's amendment.
Thank you. Mr. Shipley.
Thank you, Chair. Just in regards to this amendment, it's been a while ago, and I've already been accused of hearing things in my head, so my memory's not as good as it once was either, to my younger friends across the table, but in all good fun. We did hear from the witnesses back in the spring, early spring probably, that one of the issues with a lot of the things was resources to implement, or even to keep going right now. It was tough. A motion like this, or an amendment like this, pardon me, that would be cutting down the timeline so much. What type of personnel resources would you need, and what type of additional funds? And can anybody guess at that a little bit? Because it's quite important to implement something like this. And I know it's a quick question. And
Yeah, any comment would really be a guess, just based on the timeline. Reducing it in half, I would imagine a reasonable estimate would be doubling what we currently have devoted to working on this. But again, depending on the nature of the review, some of these reviews are very complicated with quite a number of recommendations and findings that we have to kind of look at and analyze and provide our thorough response to.
so just to recap, you said doubling of your resources for this one amendment?
Well, I'm just, again, this is not...
And I know you don't have time to write down a whole business case
just,
for this. So.
Given that the current timeline that we're operating under is 6 months, reducing it in half, I'm ballparking that doubling the resources to cut it in half might be able to satisfy it.
Very considerable then, considering we heard originally that resources were very stretched for this and additional funds were going to be needed. So thank you for that. So because of that and some other issues, I won't be able to support this amendment, but thank you.
Seeing no further interventions, all in favor of NDP 43? Opposed? That brings us to G7. Mr. Gahir.
Great, thank you, Chair. So this amendment clarifies that the CBSA and RCMP are responsible for sending their responses to PCRC interim reports to both the chairperson and the Minister of Public Safety. As it's currently written, they're only required to respond to the chairperson of the PCRC. So the minister is made more aware through this amendment, and I think this will enjoy support from all sides. Thank you.
Thank you. Any intervention? Mr. Motz.
Thank you. So what obligations does the chairperson of the commission have now? PR, yeah, you know what's it called? PRC. The Independent Complaints Commission. What obligation do they have to report to the minister now, and what are those timelines?
So our report is, a copy is sent to the minister, and the reply, which is what this amendment refers to,
Right.
is a reply from the RCMP and CBSA, currently is also copied to the minister. So it seems like this changes the existing provisions in the RCMP Act by not, the bill as written changes the existing provision where the minister was included. So the chairperson actually put forward that she would like to see the minister added back into this clause so that the ministerial accountability is there, so the minister is aware how long it took the agency to reply,
Right.
and what the nature of that reply was.
Right, so this actually came from the commission itself.
Yes.
All right, thank you.
Thank you. Oh, sorry, we have Mr. Lloyd.
Thank you. You know, we've had some recent incidents where the ministers were supposed to be informed of things and the messages weren't passed along. And so what assurances do we have that this amendment will result in the minister actually personally receiving this correspondence? Or is there a risk that it could go into a minister's office and the minister will never see it the light of day? What accountability measures can we be assured will exist to ensure that the minister's eyes are actually on this document based on this amendment?
Generally, when these types of communications are received in the department, they're provided to the minister's office very, very quickly. In my experience, often the same day. The accountability could fall to the minister in the sense of reporting to Parliament about when the commission made a report and when it was able to receive responses.
Thank you. Mr. Shipley.
Thank you. Oops, there we go. Thank you. And I know we're getting into the weeds a little bit this, and I understand what Mr. Lloyd's saying. Just to kind of close the loop, though, because we're in agreement with this amendment, could there be some type of, or would it be at all possible to have some type of an acknowledgement? I'm trying to word this nicely, as Mr. Dane was saying, too. Mr. Dane, you've been called worse. It's got to be Wednesday afternoon.
By better people, too.
Yeah, that hurt. An acknowledgement to make sure the loop is closed, so no one can just say, well, technology, it didn't get sent through. We've all heard, oh, I didn't receive the email, technology didn't happen. Is there anything that can be put through that an acknowledgement has to be made to make sure that loop is closed?
It's probably possible. Whether that's necessary in the context, I think, is a question for the committee in the context of examining the amendment.
Can you move that as a...
Seeing none, all in favor of G7? Opposed? Carried. That brings us to NDP 44. Mr. Julian, if you please.
You'll be delighted to know that since we've already discussed this, I'll be withdrawing NDP 44 and NDP 45 as well.
Thank you. Therefore, shall Clause 64 as amended carry? On division? On division. Brings us to Clause 65. NDP 45 is withdrawn. Brings us to NDP 45.1. Mr. Julian.
Thank you, Mr. Chair. And I think the concerns that were raised by witnesses, and I'll raise the number of groups in just a moment, around Clause 65, which says that the Commission's final reports are final or not subject to appeal to or review by any court. A number of organizations raised concerns about this. And so NDP 45.1 seeks to say that those findings and conclusions could be subject to appeal, are subject to appeal. That is the language that allows for the opportunity to appeal to courts. Now, the organizations, there are a couple of dozen organizations that have told us this is an important provision to have that ability if commission finding and recommendations or for whatever are not satisfactory, that they could be reviewed by a court. And that includes Amnesty International Canada et l'Amnesty Internationale section francophone. Alors,
The Francophone section of Amnesty International as well.
Liberties Association, the Canadian Civil Liberties Association, the Canadian Council for Refugees, the Canadian Immigration Lawyers Association, the Canadian Muslim Lawyers Association, the Canadian Muslim Public Affairs Council, the International Civil Liberties Monitoring Group, and so on. Very important organizations that have told us that the existing Clause 65 that basically does not provide for any possibility of appeal or review by any court is something that they find very concerning. And for the credibility in terms of the legislation, they thought it was very important to say to us that section needs to allow for the possibility of appeal. And that's why NDP 45.1 is before this committee.
Thank you, Mr. Julian. Mr. Motz.
Thank you, Chair. So a couple of questions to our witnesses. Number one, in the Commission's history, and how long have you been operating now for the RCMP? About?
Since 1988.
So in 88. So in that timeline, is it rare that we would have appeals of your decisions that would go to a court?
Yes, it's actually exceedingly rare that that complainants seek judicial review in the federal court, and the rare time that it does happen, it's almost never been a successful application.
Okay, so having learned that, like this. I understand what Mr. Julian is alluding to or trying to get at, but it's completely opposite to what's in the Act right now. And as a result, I'm troubled to know how this will actually improve service to the people who were alleged to have been aggrieved. And there's a big difference between, an appeal or thinking that you get appeal because you don't like the result of the investigation, as opposed to there was some error in law or there was some misconduct in the investigation of some way that would have tainted it. And so I'm troubled by, I have to understand more that there's no other recourse for a complaint. So if I'm complaining about, let's say, CBSA, and we go through the whole complaint process, the commission intervenes, they do their bit, and I feel as if I still hadn't been heard, does that mean that, like, I have no other recourse? Once the commission is done, I have zero recourse. That's what it's saying now under the 65, correct? Basically.
Yes, and the government's design intent there is that there not be a stage of judicial review between the conclusions of the commission and its recommendations to the minister or the deputy head of the agencies, because the commission's recommendation is not the final decision. The final decision rests with the minister and the deputy heads. They answer for it. Their decision to act or not act would, of course, be subject to review by the federal court.
Does it have anything to do with would the commission be considered to be a quasi-judicial body? Would that be something that plays into that decision as well?
So the intent is that the commission exercises quasi-judicial powers in its investigative capacity, and what you'll find in 64, which is the commission's authority to make any recommendation that it sees fit. So the commission is unfettered in that, but the decision-making authority to finally dispose of the matter ultimately rests with the minister or with the agency head about whether or not they accept the recommendations of the commission.
Do you see any challenges with adding the CBSA now into the commission's mix, that would create more opportunities for an appeal process? Or do you feel that it would be, again, the way the Act is read now in 65 is still appropriate?
The government's intent was that it is still appropriate, and 65 was drafted with the perspective in mind that CBSA is being brought in under the jurisdiction of the Commission. The logical conclusion of providing for judicial review between a recommendation of the Commission and the final decision by the Minister or the Deputy Head would be one of delay. And the intent, the design bias, if you will, throughout the new regime is that it favors faster resolutions by imposing more deadlines and by not providing for judicial review at an interim stage, if you will, which is before the Minister or Deputy Head have made their final decisions.
Okay. Thank you.
Thank you. Any further discussion? Seeing none. All in favor of NDP 45.1? All opposed? Defeated. That brings us to NDP 46. Mr. Julian.
Puisqu'on vient d'avoir les débats là-dessus.
Since we've just debated this previously, Mr. Chairperson, I'll be withdrawing NDP 46.
Thank you. And so shall Clause 65 carry? On division? Shall Clause 66 carry? On division? This brings us to new Clause 66.1 with CPC 25.
Thank you, Chair. Just had to grab my paper. We will be moving this amendment. This is CPC 25, and it is that Bill C-20 be amended by adding after line 17 on page 43 the following new clause, 66.1. If the final report finds that the complaint is unfounded and the RCMP employee or CBSA employee, as the case may be, whose conduct is the subject matter of the complaint, was suspended as a result of the complaint, the Commissioner President, as the case may be, must ensure that the employee is permitted to return to the duties of their employment and that they are paid compensation in an amount equal to the remuneration that they would have been paid if they had not been suspended. And I'll speak to that just a little bit. We did bring up a similar amendment it might have been last meeting actually, or a couple ago. This is similar, but it is a little bit different. This amendment from our previous amendment on remuneration and back pay, this amendment would automate the back pay process for complaints that are deemed unfounded. As employees who are the subject of a complaint are not paid, we would like to make sure that the process to access back pay is automatic rather than the responsibility of the employee. This would help protect our frontline workers that are disproportionately placed on leave without pay compared to managers. So hopefully we will see support around the table on that, but perhaps someone else has some other comments on that. We'll see where that goes. Thank you.
Thank you. Any discussion on CPC 25? Seeing none, all in favor of CPC 25? Okay. Mr. Clerk, if you would please.
Ms. O'Connell.
No.
Mr. Biddle. No. Mr. Gaillard.
Against?
Mr. McDonald. Monsieur Chifquet.
No. Contre.
Mr. Chapelet.
Yes.
Mr. Lloyd.
In favor.
Mr. Mutz.
Yes.
Mr. Milillo.
Yes.
Madame Michaud.
Contre.
Mr. Julian.
Oui, yes.
5 in favor. 6 against.
Thank you. CPC 25 is defeated. It brings us to Clause 67 and NDP 47. Mr. Julian, if NDP 47 is adopted, NDP 48 cannot be moved due to a line conflict, and also NDP 49 would become moot. So, Mr. Julian.
Vous serez heureux de...
You're delighted to know that I'm withdrawing NDP 47.
Such sweet words to my ear. Go to 48, NDP 48.
From Customs and Immigration Union. Concerned about the current clause that doesn't include the ability for a union representative to be informed. And of course, through this legislation, we have established collective agreements. We need to ensure that there is harmony between this legislation and collective agreements. So what NDP 48 seeks to do is ensure that the union representative is part of the duty to inform, and that it adds a new clause 1.1 that the member, person, officer, or employee, as well as their union representative, has a right to grieve the chairperson's recommendation that a disciplinary process be initiated. So this is in Clause 67, notice recommending disciplinary process or measure.
Thank you. Mr. Lloyd.
I'm inclined to be supportive of this. I just wanted to ask the witnesses, is there currently a grievance process when there's a recommendation for disciplinary action from the commission? And if there isn't, and we do move forward with this, what exactly is the process that you envision? How would somebody grieve this, and who has the authority to hear this grievance and to provide a satisfactory response to the griever?
To answer your question, sir, in two parts. The first is that the bill intends that the right of grievance would lie against the decision of the deputy head to discipline or not the employee. So again, the right of grievance lies against the decision maker, not the independent body that makes a recommendation. All of which, however, is saved by Clause 71 with the provision that nothing in 67 or 68 prevents the application of the collective agreement. So 67 and 68 are all subject to the safeguards presented in 71, which includes the existing provisions of collective agreements of the labor relations regime as a whole. Bringing a right of grievance into this statute risks bringing things into it that are dealt with elsewhere in the Financial Administration Act, in the Public Service Employment Act, and other places.
Thank you. Ms. O'Connell, please.
Thank you. I think that summarized where some of our concerns are, in the sense that if the PCRC is not able to implement disciplinary action, simply they're able to recommend, in such case, that disciplinary action happen, but the decision to actually implement or not is up to other bodies. Therefore, a grievance against the PCRC is not the appropriate measure, only because they are not, the commission would not be able to actually implement the disciplinary action. They can only recommend it. So if that disciplinary action is not appropriate, or it's, action wasn't taken and another member wishes to grieve why that wasn't taken, etc., then it's really, that grievance lies with those who implement the disciplinary action or not. And the PCRC can't. And I think that if this amendment carries, then it starts to change the bill in the extent that this bill and this process does not actually have a disciplinary component to it. So I think Mr. Coops has already explained that piece and the sections later that deal with collective bargaining or grievances that are made. So I just think it wouldn't be appropriate to allow for a grievance against the commission who are unable to actually enact the discipline itself. So we can't support this amendment.
Thank you, Mr. Lloyd.
Yeah, and I appreciated that, and I think I've gained a greater understanding of this amendment. But, it does say that it's not necessarily grieving to your the decision-making authority, the deputy head. It appears like the recommendation is saying that you have a right to grieve the recommendation from the chairperson. So is there a mechanism already? Like, isn't there a mechanism to appeal a decision by the PCRC already? So would that mean that the grievance would be kind of moot? That would be the process? Or would this appears like this is saying that we're going to add a new process to grieve decisions by the PCRC?
By adding the process of grieving the decision of the PCRC, which isn't a decision, it's a recommendation, but of the outcome of the PCRC's investigation, it adds a grievance recourse before the final decision has been made. Mm-hmm. So the final decision rests with the deputy head. It makes much more sense that a grievance follow the decision about what the deputy head does with the recommendation of the commission. There could very well be circumstances that the commission makes a recommendation that the deputy head doesn't act on, and so there would be no reason to grieve a recommendation that has not been acted on by the deputy head.
Thank you.
Thank you, Mr. Motz.
Thank you, Chair. Mr. Julian, this is your motion or your amendment, and I'm wondering, did you say at the front end where you heard this, like where this came up in testimony?
Yes.
Yeah, go ahead.
Okay. Yes, I did. Customs and Immigration Union. So they raised the concerns. Yeah. They raised the concerns about this, and that's why the recommendation has come forward.
Okay.
Any further discussion? Seeing none, all in favor of NDP 48? Opposed? Defeated? Brings us to NDP 49. Mr. Julian.
Monsieur le Président, encore une fois.
Mr. Chairperson, once again, since we've just had a debate on this particular aspect of the amendment, I'm going to withdraw Amendment NDP 49 as well as NDP 50. Now, the idea here, of course, is once we have a discussion and a debate, there are some amendments that are similar and on the same topic. But I think that we've already had a discussion and questions have been asked, and it's enough for the committee to make a decision on that basis. And if our objective here is to complete the bill and to enhance it, and there's already been a whole raft of amendments that have been adopted, well, it's more important for us to spend our time on those important elements.
Thank you. So shall Clause 67 carry? All in favor? A recorded vote? Okay.
Itsukano.
Yes.
Mr. Biddle.
Yes.
Mr. Gay.
Yes.
Mr. McDonald.
Yes.
Mr. Shifke.
Oui.
Mr. Shipley.
Yes.
Mr. Lloyd.
Yes.
Mr. Melilo.
Yes.
Mr. Matz.
Yes.
Madame Michaud.
En faveur.
Mr. Julian.
En faveur.
All in favor.
Thank you. It carries. So that brings us to Clause 68. NDP 50, which I believe is withdrawn. And it brings us to NDP 51. Mr. Julian?
On vient juste.
So we just discussed these matters, and we've just voted as well. So I'm going to withdraw NDP 51 as well as NDP 52.
51 withdrawn, 52 withdrawn as well. So shall clause 68 carry? On division? Recorded vote? Okay. Mr. Clerk, if you would.
Ms. McDonald. O'Connell.
Yes.
Mr. Biddle. Yes. Mr. Gay.
Yes.
Mr. McDonald.
Yes.
Monsieur Chiffquier. Oui. Mr. Shipley.
No.
Mr. Lloyd.
No.
Mr. Matz. No. Mr. Milelo.
No.
Madame Michaud.
En faveur.
Mr. Julian.
Ça, c'est pour.
Shall clause 68 carry?
On ne fait plus avec dissidence.
Well, I'm going to vote in favour, and it's no longer on division, is it? I'm wondering if was it on division? I'm asking my Conservative colleagues that question.
You see,
I know that, says Mr. Julian,
ralentir un processus.
but it slows down the process. You see.
It's true. I should point out that in the last hour and a bit, we've gone through 3 pages. We have, I think, 5 to do. If we buckle down, roll up our sleeves, we might get through this. So, especially if Mr. Julian keeps withdrawing amendments.
7 in favor, 4 against.
So clause 68 carries. That brings us to clause 69 and NDP 53. Mr. Julian, if you please.
Puisqu'on a déjà eu les débats.
Since we've already debated these issues, I'll be withdrawing NDP 53.
Thank you. Shall clause 69 carry? A recorded vote. Of course.
Ms. O'Connell.
Yes.
Mr. Biddle.
Yes.
Mr. Gay.
Yes.
Mr. McDonald.
Yes.
Monsieur Chiffquier.
Oui.
Mr. Shipley.
No.
Mr. Lloyd.
No.
Mr. Matz.
Sorry, no.
Mr. Melilo.
No.
Madame Michaud.
En faveur.
Mr. Julian.
En faveur, and I have a point of order, Mr. Chair.
Mr. Julian, on point of order.
We-
Excuse me, firstly, clause
7 in favor.
69 carries. Mr. Julian, on point of order.
Just on the point of order, Mr. Chair, the practice of recording vote for each clause is normally used as a filibuster tactic. We have been making good progress. Certainly heard concerns raised by my Conservative colleagues about sitting beyond 6:30 tonight, but I find it disturbing that filibuster tactics are now starting to rear their heads, and I would ask through you to my Conservative colleagues, let's stay focused on the content and improving the bill and not have filibuster tactics delaying those important considerations.
Thank you for your intervention, Mr. Julian. They certainly do have the right to ask for recorded division. Mr. Shipley, on the same point of order?
Thank you. You just took the words right out of my mouth, Chair.
There you go. Which is not to say that we could go faster and we could get done this today if we buckle down. Anyway, clause 70, we come to NDP 54. Mr. Julian.
Thank you, Mr. Chair. And because we need to improve this bill and get it through committee so it can go back to the House, we've already had the considerations around what's touched on with NDP 54, so I'll withdraw the amendment.
Okay, withdrawn. Shall clause 70 carry? Recorded vote. If you please, Mr. Clerk.
Ms. O'Connell.
Yes.
Mr. Biddle,
Yes.
Mr. Gaillard,
Yes.
Mr. McDonald,
Yes.
Monsieur Schifke, Mr. Shipley,
No.
Mr. Lloyd,
No.
Mr. Matz,
No.
Mr. Melillo,
No.
Madame Michaud,
En faveur.
Mr. Julian,
En favor. Point of order.
Clause 70, I'm sorry, I'll wait for the count.
7 in favor and 4 against.
Okay, Clause 70 carries. Mr. Julian on point of order.
Just to note, you're absolutely right to point out, Mr. Chair, that members of the committee have the right to go for a recorded vote rather than simply having it adopted on division. But each of those recorded votes, with the dozens and dozens of clauses still to come, would mean a delay of several hours and a cost to taxpayers of tens of thousands of dollars. So I wanted that noted, Mr. Chair.
Thank you. I acknowledge this, and thank you for your intervention. We come now to Clause 71, NDP 55.
Thank you, Mr. Chair. This is Clause 71, concerns that were raised by the Customs and Immigration Union. Currently, in terms of safeguards, in Clause 71, it's worded that nothing in Section 67 or 68 is to be construed as. And there's a series of measures that follow affecting the powers and rights of the Commissioner or President, authorizing the Commissioner or President to initiate any process, preventing the application of any applicable law or collective agreement, authorizing the commencement of any process or the imposition of any measure in relation to any conduct, and authorizing the collection or use of information other than the information collected or used in relation to an investigation, a hearing, or review of complaint under this Act. The concerns, of course, raised by the Customs and Immigration Union is that those safeguards only apply to Section 67 and 68. And the concerns of, for example, around collective agreement, all of the other clauses, of course, don't have those safeguards in place. So NDP 55 seeks to amend Section 71 to read nothing in this Act as to be construed as, ensuring that the safeguards apply to the entire bill, in particular the application of laws and collective agreements, as opposed to just Section 67 or 68.
Mr. Lloyd, followed by Mr. Melillo.
Thank you. I just want to ask the witnesses, the term safeguard seems like kind of vague to me, but what, in your experience, what would be the impact of this amendment on your processes?
We'd assess that the amendment raises concerns, some obvious and some might be less obvious or, in fact, unintended. The safeguards in 71 are very specifically about ensuring that the existing disciplinary processes are not affected. Changing 71, those safeguards to apply to the statute as a whole, could result in a very strange construction in saying that nothing in the statute, nothing in the Act affects the powers and rights of the Commissioner or the President when there are plenty of provisions in the Act that do that very thing. They are intended to create powers and rights of the Commissioner and the President in relation to the complaint process. So it would appear to make a safeguard provision overlarge to the point of affecting the very purpose for which Parliament would enact the statute. My colleagues from the Commission may have more specifics to offer, but I think that would be our concern about the nature of the amendment.
If I could just follow up quickly with that, Mr. Chair. When you talk about strange construction, can you clarify what you mean by a strange construction?
It would say that nothing in the Act is to be construed as doing the very thing the Act does, which is set out powers for the Commissioner and President in response to their obligations to deal with the PCRC.
Okay, seems clear to me. I don't think I can support this. Thank you.
You.
Thank you, Mr. Chair, and Mr. Lloyd sort of went that down the road. I was hoping to, just really briefly to build off it. Mr. Coops, I think you outlined clearly for me the concern with changing to this new language. Could you explain just briefly why specifically the language was chosen as it is currently?
The language was chosen to ensure that any interpretation around 67 or 68 understands the intent of those provisions, which is not to bring the Commission into the disciplinary process, not to intrude on the responsibilities of deputy heads under the Financial Administration Act and the Public Service Employment Act. 67 and 68 create what is new in 67 and 68 is not the ability to recommend discipline. The Commission enjoys that power now, and that would be covered under 64 in any event. What's special about 67 and 68 is not the power to recommend discipline. It is the reporting obligation that recommendation imposes on the deputy heads. We refer to this sometimes internally as the bad apple clause, that where a person has come to the attention of the Commission and that person's conduct raises concern but has not yet attracted discipline, that the unique power in 67 and 68 is that the Commission, by making that recommendation, obliges the deputy head to report his decision to the minister. And that entire process is intended to be separate and apart from the existing labor relations regime and the existing provisions for discipline under various statutes.
Thank you.
Thank you. Any further interventions? Seeing none, all in favor of NDP 55? All opposed? Carried. Defeated.
Yes, thank you.
I'm going to give you the recount and opposed.
I'll have to ask for a recorded vote to clarify this. This is why we need these recorded votes, because these NDP will try to sneak anything through.
All right. Sorry for the confusion. So shall clause 71 carry? All in favor? On division? Okay. That brings us to clause 72, NDP 56. Mr. Julian.
Well, after the success of the last amendment, I will press on, Mr. Chair. And this amendment actually comes from the wonderful MP for Cowichan Malahat Langford, Mr. McGregor, who sat on public safety up until the spring. The concern around ensuring accountability on this bill is very important. So what the proposal would do is amend the bill in clause 72, stating that the minister must provide a copy of the report to the chairperson and must cause a copy to be tabled in each House of Parliament within the first 15 days on which that House is sitting after the minister receives the report. Ensuring accountability, of course, to Parliament, which I think we would all agree with. Because Mr. McGregor was part of the initial hearings and heard the importance of accountability in this legislation. Through me, he is making this recommendation, and I so move NDP 56.
Thank you. Mr. Motz.
Thank you, Chair. So I'm trying to understand the language right now. So we're talking about adding, replacing lines 30 and 31, which is subsection 2 of 72 in the Act, with with the new language as proposed by Mr. Julian. So what's the purpose of a copy of the report must be provided to the chairperson in subsection 2 now? Like, doesn't the chairperson already have this? And why would this need to be there? Why wouldn't we just have, like this makes sense that the reports would come back to the House in some way. So I'm lost as to the purpose of the current subsection 2 of the Act.
The purpose of the current subsection 2 is so that the chairperson of the commission receives the reports of the agency heads to the minister so that she in turn can prepare her own assessment of their reporting to include in her report to the minister, which is tabled in Parliament. As we understand the amendment, this would cause as an interim step that first report from the Commissioner and President to the Minister be tabled in Parliament before the Minister has received the Commission's assessment of the agency's reports and before she has completed her own annual report. So you are correct, it would create a situation where the reports of the agencies to the Minister would come before Parliament twice. Once without the benefit of the committee's commentary and assessment and aggregation of data and all the rest of that, and then again later in the reporting cycle as amended, where the full report of the Commission is sent to the Minister and in turn tabled in Parliament.
Okay, thank you.
Thank you. Any further discussion? Ms. O'Connell?
Thanks, Mr. Chair. I just want to highlight as well that I think this could actually limit parliamentary oversight, because if one of the report, like if the RCMP or CBSA reports are brought before committee, for example, to respond, it might not have the benefit of the PCRC's report, and therefore committee would even be limited in asking if they've implemented all the recommendations, let's say, or what is the status on that. So it would actually, this could limit the ability for parliamentary oversight in terms of not having the full report with the Commission's findings at the same time. So that's why we can't support this amendment.
Thank you. Any further discussion? All in favor of NDP 55? Opposed? 56. I'm sorry? Sorry, I may have gone into a coma here, so that's okay. All in favor of NDP 56? Okay. I understand. Go ahead.
Ms. O'Connell? No. Mr. Biddle?
No.
Mr. Gay?
Against?
McDonald?
Nay.
Monsieur Chiffquier?
No.
Mr. Shipley? Mr. Lloyd?
In favor.
Mr. Mutz?
No.
Mr. Mililo?
No.
Madame Michaud?
En favor.
Mr. Julian?
En faveur. C'est le même problème que vous.
4 and 5 against.
5, 4, and 5 against.
We have a tie.
5, 4, and 5 against. Oh. The chair votes to defeat the amendment. So. Shall clause 72 carry? On division? Very well. Shall clause 73 carry? On division? Shall clause 74 carry? On division? Brings us to clause 75, NDP 57. Mr. Julian, please.
Et puisqu'on a dit...
Since we've already debated this particular issue, I'm going to withdraw NDP 57.
Désolé, j'ai manqué.
I'm sorry, I didn't hear what you just said, sir. I'm sorry?
So I didn't have my earpiece on there.
Oh, OK.
And my French is a little shaky.
Mais d'abord, j'avais dit que le président était...
Earlier I'd said that the chair was doing very well in French, but I simply said that I wish to withdraw NDP 57.
That brings us to shall clause 56.
L'article 75 est-il adopté? Avec dissidence? Un vote par appel nominal? Oui. Monsieur le greffier, à vous.
Sorry, are we on the clause or the amendment?
S'agit-il de l'article ou de l'amendement?
Mr. Gay.
Yes.
Mr. McDonald.
Yes.
Monsieur Chiffrier. Mr. Shipley.
No.
Mr. Lloyd.
No.
Mr. Mutz.
No.
Mr. Melilo.
No.
Madame Michaud.
Faveur.
Mr. Julian.
En faveur, oui.
7 in favor, 4 against.
Very well. So clause 75 carries. So we now come to clauses 76 to 86 with no amendments. Can we have unanimous consent to vote for them in a block? Yes. Anyone opposed? No? Okay. We shall vote for clause 76 through 86 in a block. All in favor? Opposed? Mr. I'm sorry? Well, I haven't announced the results, but he has a right to make the choice. Mr. Clerk, if you would.
Ms. O'Connell.
Yes.
Mr. Biddle.
Yes.
Mr. Gay. Yes. Mr. McDonald.
Yes.
Monsieur Chiffrier. Mr. Shipley.
No.
Mr. Lloyd.
No.
Mr. Mutz.
No.
Mr. Melilo.
No. No.
Madame Michaud.
Faveur.
Mr. Julian.
En faveur.
7 in favor, 4 against.
Very well. So clauses 76 through 86 carry. Brings us to clause 87 and BQ 14.2. Madame Michaud, allez-y, s'il vous plaît.
Thank you, Mr. Chairperson. 14.2 is an amendment that would add a provision, and that is regarding the criteria the Commissioner or the Commission must, under paragraph 38, etc., respectively, to determine whether, and so on and so forth. Why this amendment? Words are important, whether it's a vexatious complaint, a futile complaint, one that's brought forward in bad faith, and there's no definition of those in the bill itself. And that could be determined thereafter by regulation to make things clearer.
Thank you. Any discussion on block 14.2? Mr. Lloyd.
I'm inclined to support this this amendment, but I was wondering from the witnesses, do you already have processes in place to determine if complaints are vexatious and to deal with that? And so would this possibly be an unnecessary amendment to do so? Can you explain your process as it is?
My colleague can explain their process. We just observe that the government's of the view that it is actually preferable as part of the Commission's independence that it define those terms itself and apply those definitions as part of its own rulemaking authority, which is otherwise not resting with the Governor and Council, but resting internally with the Commission itself as part of exercising its quasi-judicial role, as they do now, which my colleagues can explain.
The Commission has a policy, and it's available on our website, that governs the discretion to refuse to deal with a complaint. And so we have sort of a framework around what trivial, frivolous, vexatious, and made in bad faith is, and that's how we apply. That's how we apply the discretion of the chairperson or her delegate in this case. So I don't think I can read to you the policy and the definitions we use if you'd like, or we can skip that.
Just a quick follow-up then. Is there any evidence, and have you seen cases where your framework has said that something was vexatious, but then you were challenged on that, and then it was later ruled that it wasn't vexatious? Or has your framework as it exists been successful at blocking vexatious complaints without complaints that were later found to be founded?
Yeah, it hasn't been challenged.
Any further discussion? Seeing none, all in favor of block 14.2? All opposed? Defeated. That brings us to block 14.3. Madame Michaud, allez-y, s'il vous plaît.
Merci, Monsieur le Président.
Thank you very much, Mr. Chair. So this would add a provision that for the Commission must, under subsection, determine whether it should refuse to deal with a complaint for reasons related to national security. And a regulation could be issued after the bill is enacted, and it's the Canadian Bar Association that has recommended this.
Thank you, Mr. Chair. You're getting there.
I'm working on it.
It's pretty good. Just similar to the last question from my colleague, Mr. Lloyd, I'm just curious if there already is an existing process similar to this or that might be covered under this. Just leave the question there for your comments.
We don't have a policy on this. The process usually is it's identified at the point of intake that on the face of it appears to be national security or closely related to national security. We may or may not consult with our colleagues at the RCMP if we have any questions, and they could then identify that yes or no, it's closely related. We've done that on a few occasions. Otherwise, most of the time it's fairly obvious, and then we send it to INSERA for investigation.
Okay.
Or to deal with.
Thank you.
Thank you. Any further debates? Seeing none, all in favor of block 14.3? Opposed? Defeated. That brings us to G8. Who shall move G8?
Thank you, Chair. It's okay. I'll just move that a sub-amendment that would be a 0.1 to include respecting and sharing of information and the cooperation between the Commission and the National Security and Intelligence Review Agency, or between the Commission and any other prescribed federal entity, referral of complaints by the Commission. Do I need to read all of these into the record, Miss? No? Okay, thank you. Then, Mr. Chair, with that, okay, so then I'll just go quickly to the explanation. This provides for a Governor and Council regulation making power with respect to information sharing and referral of complaints, joint proceedings, and cooperation between federal review bodies such as PCRC and INSERA. So we think this is important because if there are overlaps or things of national security matters, that we'd want them to be able to be investigated, but also protect national security matters, or on the reverse, if something were to come forward with INSERA that perhaps should be looked at through the PCRC, that this would allow that information sharing and the ability for multiple agencies to be able to do work based on these investigations. Thank you.
Writing.
Thank you, Mr. Motz, followed by Mr. Shipley. Mr. Motz, go ahead.
Thank you, Chair. So, given the explanation that Mr. Connell just made, Mr. Coops, maybe you can explain, before this was, like, what's the difference from how it's read now in H Sorry, not H.
Glenn, it might be easier if you had this in writing.
Hold on. Yeah, so this is an O, sorry, not H, an O. So with the way O is read now, under 80, what will this new sub I, sub 2, and sub 3, what will that do substantively to the Act? How would it change it? And what advantages or disadvantages is if we keep it the way it is or if we add it as proposed?
It's, we appreciate it may be a little bit difficult to follow. It's actually a new O.1, so it is not an addition to O. It would simply provide for the Governor and Council to have the authority to make regulations. This is in Section 87, the list of all the grounds on which the Governor and Council can make recommendations. This adds to that list regulations that could deal with effective information sharing between the Commission and NCIRA or other bodies, while at the same time ensuring that their independence and their respective mandates are maintained. And that is in response to a recommendation from the Chair of the Commission, and my colleagues may have more detail on that.
So the Commission regularly meets with and consults NCIRA on a number of matters, and this has come up where there could be instances where it could be related to, or would be related to a complaint where, for example, NCIRA is investigating the national security elements, but say there's a use of force aspect to it, which is not national security per se, as I think we all understand it. It's much more directly in the realm of policing and policing authorities. So how would we deal with that? And we've had these discussions. We're actually looking at starting getting into an MOU with NCIRA, but this would be much more clear if it was in regs that we could work with them. They could share the information with us, and we could exercise our mandate as they exercise theirs, just in the respective elements of a complaint.
Thank you. Are you done, Mr. Motz?
Just hold on a second. I'm done, thank you.
Thank you. We go now to Mr. Shipley.
There was some confusion. I just need a moment, Chair. Sorry.
You done?
I think so.
Okay. That being said, is there any further intervention? Mr. Lloyd?
Was this amendment, was there a new sub-amendment that was added? Like, have we been provided in writing with the
I don't believe there's a
change?
sub-amendment. I think Ms. O'Connell misspoke. This is the amendment she was moving.
There was no change to
No
it.
change.
I think that was where the confusion was. Is
You said sub-amendment, so that's
Yeah,
when we heard sub-amendment.
fair enough.
Thank you.
Okay. All in favor of G8? Opposed? Seeing none, carried. So shall clause 87 as amended carry? On division. Shall clause 88 carry? On division. Shall clause 89 carry? On division. Recorded vote? Okay.
Ms. O'Connell,
Yes.
Mr. Biddle. Yes. Mr. Gay,
Yes.
Mr. McDonald,
Yes.
Monsieur Chiffrier. Mr. Shipley,
No.
Mr. Lloyd,
No.
Mr. Motz,
No.
Mr. Melilo. No. Madame Michaud,
Faveur.
Mr. Julian,
Oui, en faveur.
7 in favor, 4 against.
Clause 89 carries. That brings us to clause 90 and NDP 58 with Mr. Julian.
Vous serez heureux de constater, Monsieur le Président, que, étant donné qu'on a déjà eu la discussion, Je vais retirer MPD 58.
Withdrawing? Yeet. See, I understood that myself. I didn't get the interpretation. Actually, that's a good thing to check on. Is interpretation working? Okay. This is a time when we all kind of go into a coma, I think, but that's my excuse. I don't know. Yeah. So shall clause 90 carry? On division? Or recorded division, okay.
Ms. O'Connell,
Yes.
Mr. Biddle,
Yes.
Mr. Gaillard,
Yes.
Mr. McDonald,
Yes.
Shifke, Mr. Shipley,
No.
Mr. Lloyd,
No.
Mr. Mutz,
No.
Mr. Melilo,
No.
Madame Michaud,
En faveur.
Monsieur Julien,
Oui, pour.
7 in favor, 4 against.
Clause 90 carries. That brings us to clause 91 and NDP 59. Mr. Julian, please.
Et, Monsieur le Président,
And once again, Mr. Chairperson, since we've already had this discussion and I don't want to unduly delay the enhancement of the bill we're studying, I withdraw NDP 59.
Thank you very much. So shall clause 91 carry? Recorded division. Mr. Clerk, if you would.
Ms. O'Connell, Mr. Biddle,
Yes.
Mr. Gaillard,
Yes.
McDonald,
Yes.
Monsieur Shifke,
oui.
Mr. Shipley, Mr. Lloyd,
No.
Mr. Mutz,
No.
Mr. Melilo,
No.
Madame Michaud,
En faveur.
Mr. Julien,
Oui, pour, en faveur.
7, 4 and 3 against.
Clause 91 carries. Shall clause 92 carry? On division. Shall clause 93 carry? Recorded vote on 93, okay.
Madame O'Connell,
Yes.
Mr. Biddle,
Yes.
Mr. Gaillard,
Yes.
Mr. McDonald,
Yes.
Monsieur Shifke, Mr. Lloyd,
No.
Mr. Mutz,
No.
Mr. Melilo,
No.
Mr. Shipley, no. Madame Michaud,
En faveur.
Mr. Julien,
Oui, pour, en faveur.
7 against, 4, 7 in favor.
So 93 carries. Shall clause 94 carry? On division. Brings us to clause 95 and NDP 60. Mr. Julian.
Thank you very much, Mr. Chair. This, I think, will be an important discussion. It is recommendation from Breaking Barriers that reservists within the RCMP should be covered by the provisions of the Public Complaints and Review Commission Act. Currently, Section 95 states that except as provided by the regulations made under subsection 1, this Act and the Public Complaints and Review Commission Act do not apply to reservists. Mr. Chair, Breaking Barriers is recommending that it should apply to reservists. It does make sense that when it comes to law enforcement and any concerns that are raised, that the Public Complaints and Review Commission really should also apply to complaints made against reservists. And so I am moving that amendment, NDP 60.
Thank you. Mr. Motz, followed by Mr. Gahir.
Thank you, Chair. With respect to this particular clause or amendment, Mr. Julian back in May asked the RCMP how many complaints there would be against, against reservists in the last 5 years. The RCMP has provided us that information, and I'd like to read that into the record as we discuss this particular amendment. The response from the RCMP to that question was number one, the RCMP Reserve Program provides access to experienced police officers to alleviate operational pressures due to planned and unplanned events, emergencies, and temporary resource shortages such as vacancies and absences. Bullet point number two, the Reserve Program provides the RCMP access to a pool of qualified former police officers to provide short-term relief to help fill human resource gaps until permanent resources are in place. The Reserve also provides the RCMP with surge capacity to quickly deploy resources to address emergency situations. Bullet point three. The RCMP acknowledges that public complaints made against reservists are not governed by the current Part 7 of the RCMP Act, and thus not subject to a review by the Civilian Review and Complaints Commission for the RCMP. The public complaint regime set out in Part 7 of the RCMP Act applies to regular members, civilian members, special constables, and supernumerary special constables. At this time, it is not applied to reservists. Point number 4. Reservists are subject to the Values and Ethics Code of the Public Service, and any complaint made against the conduct of a reservist is managed by the applicable Divisional Reservist Coordinator. Bullet point number 5. Each incident of alleged misconduct is considered. Reservist misconduct can be addressed through operational guidance, additional training, and in some cases, revocation of appointment as a reservist. Bullet point 6. Divisional Reservist Coordinators are encouraged to inform complainants of the outcome of their complaint against the reservists. Since complaints against reservists are managed divisionally, they are not provided or recorded in the national database used to track admissible public complaints pursuant to Part 7 of the RCMP Act. As such, a manual survey of each division was required to determine how many complaints have been made against reservists in the last 5 years. Based on the available reporting, the RCMP estimates that approximately 59 complaints were received by the RCMP in the last 5 years involving reservists. Since complaints against reservists are not recorded in a formal database at this time, this number represents the RCMP's best available estimate at this time. For perspective, the RCMP currently employs 462 reservists across the country. So, and I appreciate that information because I think it provides a pretty a good indication of whether or not the RCMP, the PRCC complaint mechanism and process applies to or should apply to reservists. They're obviously absent now, and I guess my question to the witnesses would be: do you see a need to add this? Is there an issue from the RCMP perspective, from the commission perspective, from the department's perspective? What are your thoughts on now adding a reservist into this mechanism and what impact that will have?
Well, maybe I can start with the policy intent behind this. The original Section 95 of the bill was to follow through on the existing mechanisms within the RCMP Act. There are things within the RCMP Act that fall outside of the complaints regime and are related to HR-related items, and so that's the reason why the bill was drafted the way it was. The way that we read this particular amendment is that it's not just about the PCRC Act, but it would also include the full application of the RCMP Act to reservists. So we do have some concerns with the way that the amendment is written. In terms of the impact of this regime on reservists, I will leave it to my RCMP and other colleagues to comment on that.
What the RCMP, what what is their impression of adding this into this particular act and the implications that that would have on you moving forward with a change to your act?
So my understanding of this, if the intent is to include reservists under the PCRC regime, I believe all that would be required would be to remove this Section 95 from the Act, and then reservists would be included in the PCRC regime, and that would give complainants the ability to seek a review from the PCRC should they not be satisfied with the RCMP's handling of their complaint against the reservist.
So if I understood you correctly, you said to take Section 95 out of the Act, remove it completely?
If Section 95 was removed, then my understanding is it would apply to, the PCRC Act would apply to reservists, and the RCMP Act would remain intact because the RCMP Act wouldn't be, would remain as is.
And if I could just maybe add on some clarity from my colleagues' comments. As the PCRC Act is written now, it talks about those appointed under the RCMP Act, and with our interpretation with Justice Canada, because the regulations to create the reserve program are part of the RCMP Act, that does include them by means of that definition, without, as my colleagues from public safety had flagged, having to encroach on all of the other parts that impact, like compensation and other HR matters. So without specifically naming them, by being silent, we do have that coverage that reservists, a complaint against them could be brought to the Commission.
Okay, and from the department perspective, what's your thoughts, Mr. Coops, on having 95 removed from the Act?
That portion of the bill is the responsibility of my colleagues in police and policy, and so they're a better place to speak to it than I am. Thank you, though.
So we recognize that this is a gap. It creates a class of individuals who are not covered under this particular section of the Act currently. But as I said, in terms of the impact on operations and resources, that would be a question for the Commission or the RCMP.
Because I'm a little concerned that the amendment, or the amendment as presented, that it applies to reservists, and yet our RCMP colleagues are saying if we take it out, it'll apply to reservists, but you don't have to change the RCMP Act. Is that what I understood correctly? So if we take out Section 95 and take out the non-applicable to the reservists, does that mean then that reservists would be included in the PCR, like this particular act, or is it going to be that they're completely removed whatsoever and there's no reference to them whatsoever? The fact that they're mentioned here.
It's our interpretation that they could be included. So if there was a complaint against a reservist, by interpreting who it applies to, the Commission could receive that if they chose to.
So then is it applicable then, or is it more appropriate to have an amendment that says we're going to take out Section 95 as opposed to this Amendment 60 from the RCMP or from the NDP?
So our concern with the amendment as proposed under NDP 60 is our interpretation is that it's not just related to the PCRC Act, but the whole of the RCMP Act.
Right.
So by changing that piece of the section, we could fix that. Like the amendment to the RCMP Act is outside of the scope of what we're trying to achieve with this particular amendment.
Okay, I understand that. So then, do you support the idea of having a 95 removed from the Act?
I would caution that the officials aren't really here to
give
give that kind of response, right?
Fair enough. Fair enough.
Mr. Motz, are you done?
Yeah.
Mr. Gahir.
Great. Thank you, Chair. So we agree with the intent of this amendment to ensure that the conduct of reservists is reviewable under the PCRC. I was under the impression that just removing the clause wholesale, clause 95, would in fact reservists would fall under the purview of the PCRC without having to amend the act. My impression was just verified by the witnesses. So we will vote against this amendment and also vote against the clause itself, which will remove Clause 95. Thank you.
Thank you. Mr. Lloyd.
Oh, sorry. Just my question. So are reservists covered under, because a lot of what we've been trying to do with this legislation is to ensure that there's there's labor representation throughout this process. And so are reservists covered by like the union or by any labor protections so that they can have advocates that can be there for them during this process? Just curious about that. Thank you.
Yes, the reservists are represented by the National Police Federation, so they are members of that, and they do have them as an advocate.
Thank you.
Chair, I'm still confused. I'm sorry. So, Mr. Gahir, you don't support this motion by the NDP, which I don't either. But if I heard you correctly, you're suggesting that to remove 95? Okay, because I don't see that as a government. I don't see that as a government amendment to the.
We'll just vote against that Clause 95 when the vote comes to clause.
Oh, I see what you're doing. Okay, fair enough.
Any further interventions? Seeing none, shall NDP 60 carry? All in favor?
Recorded vote, yes.
A recorded vote, sure. I'm sorry?
Ms. O'Connell.
No.
Mr. Biddle.
No.
Mr. Gahir.
No.
Mr. MacDonald.
No.
Mr. Shifke. Mr. Shipley.
No.
Mr. Lloyd.
No.
Mr. Matz.
No.
Mr. Caputo. No. Madame Michaud.
Favor.
Mr. Julian.
En faveur, oui.
2 in favor, 8 against.
NDP 60 is defeated.
Chair?
Yes?
Can we just have a very quick suspension for 2 minutes?
Um,
We've been here over 2 hours. Just
I
a
understand.
couple of minutes.
We could finish this clause and then take a couple minutes. How about that?
Clause 95.
Okay.
Shall Clause 95 carry? Recorded division. Go ahead.
Ms. O'Connell.
No.
Mr. Biddle.
No.
Mr. Gahir.
No.
Mr. MacDonald. Mr. Shifke. Mr. Shipley.
No.
Mr. Lloyd.
No.
Mr. Matz.
No.
Mr. Caputo.
No.
Madame Michaud.
Quoi?
Madame Michaud.
No. Contre. No.
Mr. Julian.
It's unanimous, Mr. Chair. No.
Well, Clause 95 is negatived. So, yeah. Okay. So I don't think there's a will to suspend at this time. We are getting so close. We have 3 or 4 pages. We could finish this in short order. Let's carry on, if we could. So shall Clause 96 carry? On division? Okay. Brings us to new Clause 96. Yes?
Chair, I'd like to introduce a motion, if I could, please.
In respect of what?
A motion that has been placed before the committee. It's been given notice a couple weeks ago. And that it's about, and I'll read the motion, that given the CSIS director, David Vigneault, told her Five Eyes allies that the dictatorship in Beijing is targeting Canadian universities, saying, and I quote, "Everything that they're doing in our universities and in new technology is going back into a system very organized to create dual-use applications for the military, end of quote.
Point of order, Mr.
And that
Chair.
the committee invite the director of CSIS to brief the committee on his efforts to set up a research security center.
Point of order.
Ms. O'Connell on a point of order.
Thank you, Mr. Chair. Given that the motion was duly, notice was given, however, we're not in committee business, and it's not relevant on the topic, I would suggest that this motion is out of order at this time.
Thank you. It is, unfortunately, I did recognize Mr. Motz, and notice is given, and so it doesn't have to relate to the business at hand. So Mr. Motz can continue with his motion at this time.
Thank you very much, Chair. I think it's important for the committee to start looking at some of the work that Canadians expect us to do. It is topics like what's in the motion about the universities and about what the security threat that China is to this country, that protect Canadians from the real and present threats that are out there in the world and that are at the doorsteps of us Canadians. Now, while this government continues to ram through bad legislation, the director of CSIS, which is our Canada's top spy, and our Five Eyes partners, whom we have basically ignored and abandoned in the last 8 years, is sounding the alarms and imploring us to do our jobs as politicians. Chair, I've heard the director of CSIS inform us of how important it is that we let the NDP and Liberals ram through legislation, but he also says dictatorships in China or in Beijing targeting Canadian universities, and everything they're doing in those universities and in new technologies going back into the system, very organized to create dual applications for the military. That should make the hair in the back of our neck stand on end, Mr. Chair. It's time this committee starts taking our role seriously and start listening to Canadians. When it comes to what this country needs, I think it's important that Canadians should help us decide that and not necessarily the PMO. I think that having the director of CSIS come to this committee and have an opportunity to use this place as a nonpartisan tool to protect democracy and explain the fears that he has to this committee and inform us of how we can better act to protect all Canadians would be a necessary part of the work of this committee. Chair, the fear of foreign espionage, foreign interference, and targeting is not new. And it is also not the first time that the director has tried to make us aware of the problems that we face as a country. The National Security Intelligence Committee of Parliamentarians in 2019, in Chapter 2, the government's response to foreign interference, makes reference to this specifically, that on the point of interference with academic institutions, for the benefit of the committee, I'm going to read a couple of sections of that report.
Point d'ordre, Monsieur le Président.
On a point of order, Mr. Chair.
Point of order, please.
Merci. Je comprends que vous avez...
Thank you. I understand that you've taken the decision that my colleague's motion is in order. Now, are we on debate now? And if so, could he please tell us how long he intends to speak for? He seems to have a big pile of papers, and we were dealing with C20, and I'm wondering if we'll be able to turn our attention back to C20 in the next few minutes or so.
I suspect that we are not going to get back to the C20 tonight. And in that regard, I wonder if it's the will of the committee to invite our witnesses to withdraw. Yes? No? Okay. That being said, Mr. Motz, carry on. You have the floor.
Again, this is the report from 2019, the annual report from 2019, where NSECU spoke specifically about interference with academic institutions. They say in paragraph 171 that some states carry out foreign interference activities on Canadian post-secondary education campuses. They seek to utilize the open and innovative features of these institutions to feature their own objectives, which include interference activities, but also other actions with hostile intent. Example, espionage and intellectual property theft. Foreign interference activity seeks to influence public opinion and debate, thereby obstructing fundamental freedoms such as speech and assembly and the independence of academic institutions. And trying to influence public debate at academic institutions, foreign states may sponsor specific events, to shape discussion rather than engage in free debate and dialogue. They also, may direct or indirectly attempt to disrupt public events or other activities perceived as problematic. As CSIS noted, the Chinese Students Scholarships Association are an important support mechanism for international students studying abroad and, I quote, provide a social and professional network for students. They are not nefarious in and of themselves. However, there is growing public concern about the relationship between the Chinese Student and Scholarship Association and the PRC's embassies and consulates, as the Chinese Students Associations are one of the main reasons the Chinese authorities use to guide Chinese students and scholarships on short-term study abroad. In the United States, the Chinese Students and Scholarships Associations are mobilized to protest campus events that threaten to show China in a negative light. Though ties with the Chinese government vary from chapter to chapter, there is reportedly growing ideological pressure from the embassy and consulates. Some, and I'll use the acronym for these, the Chinese Students Association is the CSSA's already mandate loyalty
Point of order,
to the
Mr. Chair.
party.
Ms. O'Connell, on a point of order.
Thanks. Do we have any printed copies available?
The motion? Should have, yes.
I believe they were distributed by email.
They were. I just like to see if it's the same motion that was read into the record. So if we have printed copies.
The clerk says he can get us some printed copies in a couple minutes. So. Thank you.
Yeah. Thank you. Though ties with the Chinese government may vary from chapter to chapter, there is reportedly growing ideological pressure from the embassy and consulates. Some CSSAs already mandate loyalty to the party line. CSSA behavior may also pose a threat to freedom of speech and of assembly. For example, a media report discussed a Toronto-based chapter of the CSSA that immediately informed the Chinese consulate and publicly condemned a presentation at McMaster University by Ruki Turdish, a critic of the PRC's internment of the Uyghurs. Pardon me? Oh, okay. Chair, if we want to suspend until we get that motion printed off for everybody, that's fine. Okay, excellent. As part of the PRC's cultural influence efforts abroad, the Chinese government funds Confucius Institutes that teach Chinese language and culture, including calligraphy, food, and dance. For example, there are now more Confucius Institutes in Africa than the number of cultural centers of any other government except France. In Canada, these institutes are typically affiliated with post-secondary education institutes and K-12 schools. CSIS notes that New Brunswick recently shut down a Confucius Institute due to community complaints related to foreign interference. In the United States, the Permanent Subcommittee on Investigations for the Committee on Homeland Security and Governmental Affairs recently completed a review of these institutes in a report entitled China's Impact on the U.S. Education System. The report noted, and I quote, Confucius Institute funding comes with strings that can compromise academic freedom. The Chinese government approves all teachers, events, and speakers. Some U.S. schools contractually agree that both Chinese and U.S. laws will apply. The Chinese teachers sign contracts with the Chinese government, pledging they will not damage the national interests of China. Such limits and limitations attempt to export China's censorship of political debate and prevent discussion of potentially politically sensitive topics. Recent Canadian media reports have highlighted similar concerns, including a January 2019 article that discussed the rejection of a Confucius Institute agreement by a Toronto school board. The committee believes, this is the committee being NSECOP, there is ample evidence that Canada is the target of significant and sustained foreign interference activities, that the PRC, the Russian Federation, and other states, that the committee believes that these states target Canada for a variety of reasons, but all seek to exploit the openness of our society and penetrate our fundamental institutions to meet their objectives. They target ethno-cultural communities, seek to corrupt the political process, manipulate the media, and attempt to curate debate on post-secondary campuses. Each of these activities pose a significant risk to the rights and freedoms of Canadians and to the country's sovereignty. They are a clear threat to the security of Canada. And Canada is not alone in facing this threat. Its closest security and intelligence allies, including those within the Five Eyes and NATO, are targeted by many of the same states using many of the same techniques. Like terrorism, the threat of foreign interference is increasingly seen by states as a growing threat requiring a common response. Now, Chair, I'd like to turn the committee's attention to the report by NSECOP report from 2020. The last one was in 2019, submitted to the Prime Minister in December of 2020. Now, although I know the members of the committee would like me to read the entire 62-page report, I will not. But I will read the sections of the report that directly speaks to the content of the motion that I presented. 2018, the committee here being again, this is from the report on espionage and foreign interference from NSECOP. The NSECOP committee identified espionage and foreign interference as growing threats that will likely require a more significant response in the years ahead. Espionage and foreign interference threaten Canada's sovereignty, prosperity, and national interests. These threats target communities, governments, businesses, universities, and technology. In 2019, the committee reviewed the government's response to foreign interference and found that foreign interference activities pose a significant risk to national security, principally by undermining Canada's fundamental institutions.
Point of order. Point of order, Mr. Chair.
Point of order.
Ms. Finley on a point of order.
There is so much conversation going on that side of the room that I can barely hear
Let's not
my
have
colleague
crosstalk.
just 2 microphones away.
Thank you. Thank you.
So, excuse me, you're interrupting me. I have the floor.
Hold
It
it.
is my point of order. It is my point of order, and I have the floor.
Come to order, both of you, please. One at a time. I understand there's some
Mr.
noise.
Chair, the noise is so loud with at least 5 conversations going on that side of the room that I was having trouble hearing my colleague, who is only 2 microphones away from me. I think if we could call it to order, I would appreciate
I
that.
just did. So thank you for your intervention, and things have quieted down. Thank you all. Mr. Mott still has the floor. Are you raising a point of order? Mr. Julian on a point of order.
Thank you, Mr. Chair. Things have deteriorated, so I move adjournment.
Thank you. A move to adjourn has been made. All in favor of adjourning at this time? All opposed? Okay, so I don't think we're kind of listening here. So we have a motion to adjourn on the floor. All in favor of adjourning at this time, please signify. All opposed? Very well. We are adjourned.